Hey, responsible gun owners, are you worried about self-protection, defense? If you get into a shooting, don't call second call. Stand by for my analysis. Hey guys, Attorney Marc J here. I'm the founder and president of the Attorneys for Freedom Law Firm. And today I am going to review the second call defense member commitment package. All right, so we know what this is about. I've done many of these other reviews for other companies in the past. This is for responsible gun owners who might get involved in a self-defense shoot and then get charged with a criminal act. You're worried about being able to afford criminal defense services and a whole bunch of other things. Let me tell you why I don't recommend second call. As always, don't take my opinion on anything. Read the contract for yourself. I've got it right here in my hands. Let's start with page 4, just kind of a warm-up. All right, second call. It's not available in all 50 states. It excludes residents of Washington, New York, New Jersey. So if you're a resident of one of those states, you're out. Second call, unavailable for you. All right, no big deal. Moving right along. I want to go through some of the language on page 6 of the second call defense contract. Here's what it says. Primary member and secondary member, if applicable, acknowledges that components of the protection plan relating to civil suit defense costs, civil suit damages, accidental shooting protection, and lost, stolen, or loaned firearms liability are backed by an insurance product. The plan terms and conditions may be changed at any time at the absolute discretion of second call defense, and second call defense's only obligation is to provide the primary member with an updated version of the membership agreement posted on the second call defense website. So it's insurance backed, no problem. They can change the plan at any time. They'll let you know if they do. So if you want to know about second call defense and what's included, don't look on the website and don't talk to the representative. Why? Because they may not be giving you accurate information. Let me read from page 6 of the second call defense plan contract. Quote, informational statements on second call defense's website or made by second call defense representatives regarding the protection plan services and other content are for general description and informational purposes only. Do not constitute professional advice of any kind and are not warranted as to their accuracy. Second call defense does not make any general or prospective representations that protection plan services do or do not exist for any incident or type of incident under the protection plan. Continuing on page 6, statements from representatives of second call defense and on the second call defense website or any other publication are for informational purposes only and are for an updated version of the membership agreement terms posted on the second call defense website and are not binding on and do not amend, modify, or supplement the protection plan services. Okay, so if you want to get right to the meat of why you shouldn't call second call, all you got to do is take a look at Exhibit A to the contract, which is page 9. All right, we're looking at Exhibit A, page 9. It looks like this. It has 3 columns, basic, defender, and ultimate. First thing you might notice is that financial support, it's only on the ultimate package that you get immediate attorney retainer up to $10,000. All right, $10,000 as a retainer isn't going to get you, in my opinion, a highly experienced criminal defense lawyer on a serious case. They're going to want far more than that. But that's not really the problem here. If you go to the bottom of Exhibit A, what you'll see is legal protection criminal. And then you'll see an asterisk right across the board. Same for basic, same for defender, and same for ultimate. Each one of them has an asterisk next to it. And each one of them says criminal defense grant up to $100,000. What does that mean? Let me first start by saying $100,000 is not going to be enough money if you take a serious felony case all the way to trial. It is definitely going to exceed $100,000 with any experienced criminal defense lawyer. That is not going to get you there. If the cap's $100,000 and you want to go to trial, you will very likely be paying a substantial amount out of your pocket. Experienced criminal defense lawyers will tell you in a serious felony case that goes to a jury trial, you can expect $200,000 or $250,000 just in attorney's fees. That doesn't include court costs, investigator costs, expert witness fees. $100,000 isn't going to get you there. But that's not even the big problem. Remember the asterisk I told you about that's on each of the three? Take a look at the bottom. It's always in the fine print, right? At the asterisk, here's what it says. Second Amendment Support Foundation. Reading from the middle of this small print paragraph at the bottom on Exhibit A, page 9, here's what it says. The foundation exists to provide grants of up to $100,000 for responsibly armed gun owners who face criminal prosecution in other situations such as red flag laws, emergency risk protection orders, gun confiscation without due process, and more. The Second Amendment Support Foundation is not associated with or included in the second call defense membership, and specific grant amounts are not guaranteed. Grants are available to all American gun owners subject to the foundation's approval process. Are you kidding me? This entire $100,000 with the asterisk at the bottom that's dedicated for criminal defense services is all contingent on the Second Amendment Support Foundation, which has nothing to do with, in their own words, is not associated with or included in second call defense membership, and grant amounts are not guaranteed. That's the meat and potatoes of why you're purchasing this thing. And you got no rights to anything in terms of criminal defense services under this contract. And not only that, the $100,000 grant that you may or may not get as a member of Second Call Defense is available to any American gun owner. As they said, grants are available to all American gun owners subject to Foundation's approval process. Now look, nothing against the good people at the Second Amendment Support Foundation, but that is not part of Second Call Defense, and you got no guarantees to any money under any circumstances under this contract in terms of criminal defense protection if you're a member of Second Call Defense. I hope you really think that over. If that's what you're looking for, guaranteed to have an attorney who's going to fight for you if you're charged with a major felony offense and you say, hey, I acted at least in good faith, I thought I was acting in self-defense, no guarantees with Second Call. It's completely up to a different organization, Second Amendment Support Foundation, who may or may not decide to give you a grant up to, but no greater than, $100,000, which in my opinion will not be anywhere near close to cover you if you want to go to a full-blown jury or bench trial on a major felony charge. Is there anything else you really need to know about Second Call? It's all up to the Second Amendment Support Foundation, which anybody can ask for the grant from them. You may or may not get it. You don't get any benefit here from what I can tell under this contract after reading Exhibit A for being a member, at least as to criminal defense, to pay your lawyer in a criminal defense. Now, there's an insurance contract which may or may not apply for all of the other bells and whistles, which I'm going to talk about in just a minute. But essentially, there are two parts to the Second Call Defense program, right? Part one, the insurance program, which covers everything other than the criminal defense services. And this makes sense if you think about it, right? Because they're trying to get around the problems that involve insurance companies paying for criminal defense services. It's a real problem. Instead, they're saying, hey, you probably, or maybe, or likely, or who knows if you will or you won't, get a grant from the Second Amendment Support Foundation up to $100,000. Okay, anybody can apply for this grant. I don't see the benefit. If what you want is a criminal defense lawyer representing you if you get charged with a major felony, I don't see any benefit to the Second Call Defense program. Is there anything else I need to say about why you shouldn't call Second Call after that? Again, do not take my opinion for it. Read Exhibit A for yourself. Don't forget about the all-important asterisk next to criminal defense grant up to $100,000 where it says legal protection criminal. This is why you need to read the fine print. Incidentally, feel free to read the fee agreement for the attorneys on retainer program, because now I'm going to get into the exclusions, as if you needed anything more to discourage you from second call. There are still more exclusions. Don't forget to look on page 15 where it says up to $100,000 criminal defense protection. Starts out really good, right? Legal fees required to successfully defend you in a criminal case can be overwhelming. Absolutely true. Very next line, you may have access to as much as $100,000 for legal fees to assure you don't end up convicted or feel pressured to make a deal with the prosecution simply because you can't afford a good defense. Sure, that sounds great, but you may have access? Why do they say may have access instead of you do have access if you're a member of this program? Why do they say may? Because it's not up to second call. It's up to the Second Amendment Support Foundation. They get to make the call, and they're not affiliated with second call. That's why it says you may have access to as much as $100,000. You may not even get the $100,000. You may get zero. You may get something less. Is this the plan you want to feel safe and secure if you get into a self-defense shooting? I'm thinking probably not. Just to be sure, take a look at page 21, right in the middle of the page. I'm going to read verbatim from the contract. The Second Amendment Support Foundation, Inc. is not associated with or included in the second call defense membership and is not a guaranteed member benefit of second call defense membership. Access to the Second Amendment Support Foundation, Inc. is available to all second call defense members and responsible American gun owners, end quote. Could this be any more clear about what you're getting and what you're not getting when you join second call? And by the way, if you're wondering about the insurance component of this, you can also look at page 9 at the very bottom. It tells you all insurance-related products are exclusively marketed and sold by Rockwood Programs, Inc. That's the insurance company you're dealing with when you buy a product from second call. All right, here come the exclusions, as if you needed any more reason to avoid second call. Take a look at Exhibit B, page 10. It says, after a second call defense member uses any legal weapon in self-defense. Of course, it's got to be a legal weapon. Not sure about that? Take a look at page 11. Very clearly, middle of the page, covers all legal weapons, including firearms and knives. Okay, no big deal. Many of these other programs don't cover illegal weapons. Attorneys on retainer, no problem, even if you have an illegal weapon. Keep in mind, there are many ways to have an illegal weapon, right? You could have a serial number problem, length of barrel problem. You may have a trigger issue that the ATF decides, oh, it's a fully automatic weapon. Any of these problems that the company can say, hey, it's an illegal weapon, no coverage for you under this program. No problem under attorneys on retainer. Okay, so page 18, here come the parade of exclusions. Remember, this is going to be for the insurance side of things. You want criminal defense, you want a lawyer paid, you got to talk to Second Amendment Support Foundation. But on page 18, here's exclusions. First, this member benefit policy does not apply to any claim or event based upon arising out of directly or indirectly or in any way related to or involving any actual or alleged a criminal act by any member, end quote. So of course criminal acts are excluded, but not just actual criminal acts, alleged criminal acts. An alleged criminal act by a member is excluded. Well, I don't know how they're going to interpret this, nor do I know how a court would interpret this, but if you want to say an alleged criminal act is excluded, I don't know. To my thinking, that probably includes an indictment or a criminal complaint. Indeed, that is a formal allegation of a criminal act by a member. This certainly could be read to say if you're charged with a crime, you are therefore alleged to have committed a criminal act, and therefore the civil side, the policy coverage, the insurance coverages are hereby excluded. Okay, I don't know how they're going to interpret that, but that's what it says. Alcohol and drug use, Were you drinking some alcohol? Were you using some drugs? Again, you don't get to decide when the self-defense incident occurs. It might occur when you're out in town at a restaurant, maybe you had some wine or a few beers. Take a look at page 18, section C, under exclusions. Excluded, the use of any weapon by any member while under the influence of any intoxicating substance, narcotic, controlled substance, or alcoholic beverage. Those are all in the plural as well. So it's pretty clear if you're using any of these or under the influence of any of these, no coverage for you. Again, not a problem with the Attorneys on Retainer program. Doesn't matter to us if you were drinking or using drugs. If you were charged with a felony that arises out of something that occurred after you signed up and you say, hey, in good faith, I reasonably acted in self-defense, even if it turns out to be a criminal act, you are covered with the Attorneys on Retainer program. Staying on page 18, subsection I, domestic relationships. Okay, we shouldn't be surprised here. Many of these companies simply don't cover domestic relationships. Incidentally, this is probably one of the most likely situations that a self-defense incident is going to arise, right? Things get heated sometimes. Ex-boyfriend, ex-girlfriend, ex-wife, ex-husband. Here's what subsection I excludes: domestic relationships. Second call defense will not provide member services for any domestic violence or relationship incident, related criminal investigation, or prosecution arising from a use of force incident involving a second call defense member and a current or former member of the household, including, but not limited to, a current or former spouse, adult, or minor child, or involving those in a current or former dating relationship as defined by applicable state law, end quote. So if you have a self-defense incident and it involves somebody who's alleged in a domestic relationship, no coverage for you as to second call defense. Maybe interesting to point out on page 19 under definitions where they talk about subsection B, where they talk about act of self-defense or defense of others means conduct, and then it gets into the definition, but in the paragraph, and I won't go through the whole thing, again, page 19 under definitions, section B, it talks about a member in all respects is legally justified and therefore not an illegal or criminal act, right? They don't cover those. At the end of paragraph B, it says any force used must be reasonable under the circumstances and proportionate to the threat, and B, the act is permitted by applicable law. Well, that's exactly the problem you're trying to deal with, is the prosecutor is saying what you did is not permitted by applicable law. That's why you're charged with a crime, because the prosecutor and the prosecutor's expert think what you did is not justified in all respects under applicable law. If you take a look at page 20, section P, legally justified act means conduct of a member in the threatened or actual use of a legally possessed weapon by a member that is done in such a manner that the said conduct of the member in all respects is legally justified and therefore not an illegal or criminal act. Pretty clear what's going on here. You're dealing with an insurance company. Insurance companies simply can't cover illegal acts. They can decline the insurance portion of the coverage from second call if it's determined you committed an illegal act. All of these problems are pretty consistent with other insurance companies. Second call is maybe unique from the ones I've reviewed because they don't even guarantee that you're going to get any money for your criminal defense lawyer if you're charged. That's all a function of what an unaffiliated, unconnected part of your policy, the Second Amendment Support Foundation, what they may or may not decide to do. That's up to the good people at the Second Amendment Support Foundation, but you don't get that included as part of your second call membership. Based on what I've read in the contract, and make your own judgment on this, I don't know how it will be interpreted either by second call or by a court, but it seems pretty clear. The money that you need to pay a criminal defense lawyer is a function of what the good people at the Second Amendment Support Foundation decide, having nothing to do with the people at Second Call Defense, not even included as part of the Second Call Defense membership. We shouldn't be surprised by all the various exclusions. The rest of it is provided by an insurance company. We know they can't cover criminal acts. Again, what happens if you plead guilty? Sure, in your criminal case, if you plead guilty, like the vast majority of people do, I mean, we're trial attorneys at our firm. We love to take cases to trial, but it's always the client's decision to take a plea. What happens if you take a plea and you plead guilty and then you get sued civilly? Sure, you may have great civil coverage from the insurance company, but if you've already pled guilty, guess what? Now you've admitted to a criminal act, and the insurance company cannot cover a criminal act. You are left hanging. Okay, how do you avoid all this? You don't sign up with the second call, people. Maybe from very nice people, but not such a great policy. Instead, you take a look at Attorneys on Retainer. We're a real law firm. We don't have these problems with covering criminal acts. You don't have to guess about who your lawyer is going to be. You don't have to call and speak with one lawyer on the hotline and then see who they can line up, maybe within 24 hours, to get a different lawyer on. The lawyers you speak to at the Attorneys for Freedom law firm is the same team of lawyers who's going to defend you if they're coming after you for a major felony and you say, hey, I acted in good faith and reasonably in self-defense, you're covered. It doesn't matter how it turns out. We don't have any of these exclusions. Take a look at our contract. It's right there online for you to take a look at. You can read our contract, learn about our law firm. We've been in existence 27 years. I personally have been representing people for over 30 years in major felony cases. I've done several death penalty, alleged first-degree murder cases at trial, many gun cases, all the way down to simple crazy misdemeanors. We represent people, and our program is available nationwide in all 50 states, no problem. We pay the Pro Hoc Vice fees. We'll get admitted to your state for the purpose of representing you on your case. No additional fees to you, no travel expenses. All the court costs are covered, investigator fees, expert witness fees, civil defense, all of these various bells and whistles. Check out the contract for details, but everything you want is included in the Attorneys on Retainer program. Check it out. Look for the big red button top right on the home page at the Attorneys for Freedom law firm. It says Attorneys on Retainer. Click that. It'll give you all the information you want right there. You can sign up very easily online, or if you have questions, just give us a call. We're happy to chat with you and explain everything to you over the phone. If you want to talk to me personally, no problem. I'm easy to get a hold of. If you like this video, like and subscribe. You want to leave a comment, agree or disagree, no problem. If you bring it civilized, you'll get a comment back from us. Again, my name is Marc Victor, owner and founder of Attorneys for Freedom law firm. Thanks for listening.